juror out and chat briefly, but he may need to be excused. Anything before, I'll give you a thumbnail of that in a minute. Any procedural matters we need to take up from the state?
Nothing on behalf of the state.
Okay. Anything from the defense? Okay. Good morning, Mr. McIver. Juror 42 is in the midst of a family emergency. I'm going to let Juror 42 talk to you all about it, but it sounds like Juror 42 needs to be at Northside Hospital right now with family. So I just think we need to hear from him, and then depending on what flows from that, let him go. Well, let's see if you could bring out Juror 42, please. That's a big screen. Is that...
it's only for the opening, it won't be for the trial.
Okay. Will it project in a way that the defense can see it? Okay. So they don't have to stand behind the jurors to see what's going on in the opening. Okay. Maybe it'll be on this little monitor, too. We'll see. You can take a seat, 42.
Okay.
I'm going to stand only because with this flotilla of screens, I don't think I could see you.
Okay.
I was forwarded your voicemail. We didn't ignore it. We needed you to come down here so that the parties could hear the issue as well. And we can be vague about it, but it wouldn't have been appropriate for me to authorize anything without everyone having a discussion about it first. My understanding is that your mother is not well and may require surgery. You are the sole surviving child, relative, etc., and she's not in a position to necessarily be making fully informed decisions on her own, and so you want to, opt to, and need to be at that hospital to assist with decisions that need to be made, not next week, but today?
Correct. Yeah,
Okay.
she's there now. We're waiting on the surgeon to come in after reading the MRI. I don't mind giving out a little bit of detail. But yes, I am. I lost my brother last year and my sister years ago, so I am the only child. My mother's 86. She has a little bit of dementia, so add this in with the stress that she's going on. It's a little hard for her to make decisions. My wife and I tag team getting her to the hospital, to the ER last night, to Northside. And we thought that was going to go in and come right back out with a normal stomach upset or something, but it turned out that the ultrasound showed that her gallbladder was inflamed and needed to come out, and then they're doing an MRI, and then the surgeon's wanting to confirm all of that and then talk about the options that need to be made.
So all of this is an upsetting situation, but also something you couldn't have forecast when we were talking last week.
No, her health is, for an 86-year-old, has been fine for a while. So these are these kind of things you just don't know.
Okay. Mr. Rucker, do you have any questions for Juror 42?
No, sir.
Mr. Harvey?
Thank you.
No, sir.
Okay. If you don't mind, step back into the jury room. I'm going to talk with these folks for a moment, and then Deputy Murphy will let you know what's happening.
Okay.
Thank you, sir. And good luck.
Thank you. I appreciate it.
Mr. Rucker, anything you want to add? It seems like Juror 42 ought to get up to Northside ASAP. His voicemail to Ms. Nelson was, could you tell me so I can turn around?
Right.
I'm heading south. I'd like to head back north. And I told Ms. Nelson we can't give him that relief quite yet.
Right. I agree with the court.
Okay. Mr. Harvey?
I'm sorry. I just said, can I have my lawyer answer?
Sure. Mr. Samuel, as the agent of Mr. Harvey?
I have full authority. No objection.
Okay. Deputy Murphy, we're ready for the other, now 15 jurors. If you would please let 42 know that he's excused and tell him we all wish the best for his mother.
I will, Judge.
Thank you.
Before we go into my situation, I will use the fire, the gun. In my opening, it has been secured. I let the deputies know about it. But I just want to let you know if you want to tell the jurors so they can extend it.
Okay.
And is it also possible for Mr. Abadi to sit at the witness chair?
Sure. Do you want to sit in the witness chair?
He has to stay there very much.
And we get to cross.
Yes, that's fine. Thank you for flagging both those things. And I think I said this before. I know I said it before. I don't know who all was in the courtroom. During the jury selection phase, for a while, it was appropriate that representatives of the media were cordoned in one area. Other than the camera, media folks can sit wherever as long as they're not elbowing people out of the way. You get here first, it's your seat. But there's not a requirement that media sit behind the smoked glass, again, other than our camera. Where are they? We need notepads and pencils or pens, please. They can come on in, and we'll let them know they're coming. Thank you. Is the defense determined if it's going to give an opening at all, and if so, now versus later?
Yes.
And the answer is?
Yes.
No, I said yeah, but yes as in now,
Yes.
or okay, now-ish, not after the state rests.
All rise for the jury.
All jury members are counted and present for Your Honor.
Thank you, Deputy Murphy. Good morning, ladies and gentlemen.
Good morning.
You all can be seated. Thank you for being on time. One of you snuck in at about 8:59, but we're ready to go. As you can see, we're now numbering 15 jurors, not 16, but I appreciate you all being back. We are going to get underway in just a moment. I need to work through some preliminaries with you all before the trial can get underway. One thing I want to tell you is about seating. There is no assigned seating. You all can sit anywhere you want, and I encourage you to not always sit in the same seat. In fact, I'll probably poke at you a little bit if I see number 5 always way in the back corner, or the gentleman in the green sweater always up in the front, because you literally see things a little bit differently depending on where you're sitting. And your observations of witnesses, of attorneys, of the defendant, of whatever, may inform some of the decisions you have to make. So don't grab a seat and make it yours unless there is sort of a health and wellness reason why you need that seat. A couple of the seats, it's easier to stand up if you need to stretch. I don't recall any of you saying you had a need to stretch regularly because of a back or a knee or something, but That one empty seat affords you the opportunity to do that. But otherwise, again, there are no assigned seats. Mix it up a little bit. Second thing I want to tell you has to do with the notepads. You are free to take notes. You are not required to take notes, but you should understand that you will not get to replay witness testimony. When you get to deliberations, there will not be a transcript there that would be about 50 phone books thick of what everyone said during the trial. When you are deliberating with your colleagues, you will be basing your recollection of what was said or wasn't said or what the conflicts were or weren't in testimony based on what your brain remembers and what you may have written down if you take notes. You are not required to take notes, but you're welcome to do so. Your notes must remain private until you begin your deliberation. So when we take our first break today, if you're a note taker, don't go back in the jury room and say, can you believe, look what I wrote down. Can you believe person X said Y? Those reactions are to be shared after you've heard all the evidence. Because you may hear witness X say Y, and that may seem remarkable until you hear witness Z say the same thing or say the opposite thing. And so you can't put it into context until you've heard all the evidence of the case. So feel free to take notes. They need to remain private until you begin your deliberations. Don't let notes distract you from what else is going on. Some folks get so into their notes they never look up. The next thing you know, all the other jurors have gone in because it's break time. And you may miss something that to you might be significant. The way in which a witness starts to react to questions. Is the witness sitting up straight? Is the witness sweating? These are all things that you may choose to weigh when you are assessing witness credibility. I'll talk about that in a minute. But if your nose and eyes are buried in your notes, you're going to miss other aspects of the trial. So no requirement to take notes. You're free to do so. They need to remain private until you deliberate. And I'll mention this again just before you deliberate, but keep in mind that if someone has written something down, that's not entitled to any more weight than what you remember. Just because someone wrote down that the person said the light was red, and you remember that the person said the light was green, you shouldn't change your mind just because someone wrote it down. If you're convinced that that's a better way of recalling something, you can choose to change your mind. But notes aren't to be given any more weight than your independent recollection of what someone said or did during the course of the proceedings. And if you fill a notepad, let us know. We have more. Infinite supply of notepads and pencils. If you're a pen person, you probably need to provide your own pen. I think we only can afford to provide pencils. But we have more pencils if your pencil runs out or gets dull or something like that. So that's what I have to tell you about notes. What I'd like you to do now, even though you just settled in, is to stand up. I need to administer a different oath. You took the voir dire oath, those many days ago. Now you need to take the juror oath. So if everyone's standing, please raise your right hand. Do you swear or affirm that you shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and Claude McIver, who is charged with murder, felony murder, aggravated assault, influencing witnesses, and a firearms offense, and a true verdict give according to the evidence? Please say yes if you so swear or affirm.
Yes.
Does anyone not so swear or affirm? Okay, please be seated. You are all now officially jurors. Before we begin the trial, I need to talk to you a little bit about some fundamental principles of law that you ought to be keeping in mind as you process all the evidence that you see and hear during the course of the trial. I also need to talk to you a little bit about my role, your role, and the lawyer's role. This is a real trial. It's not TV, and things here happen the way trials actually happen, and not Perry Mason, Law and Order, CSI, Special Victims, whatever you all may watch or have seen during the course of your life. And it's important that I share some of that with you. The defendant is charged in this indictment with various crimes. Crimes are violations of the laws of the state of Georgia. I'm going to read to you now the specific charging language of the indictment. If some of the language seems a little formalistic, don't panic. The indictment will go back with you during your deliberation. So feel free to take notes, but you'll have this very document with you during your deliberations. The defendant is charged in count 1 with the offense of murder, and the allegation is that the defendant here in Fulton County on September 25, 2016, did unlawfully and with malice aforethought cause the death of Landa Diane McIver, a human being, by shooting her with a handgun. Count 2 charges the defendant with the offense of felony murder. And the allegation is that he, again here in Fulton County, on that same day, September 25, 2016, did unlawfully, during the commission of a felony, that felony being aggravated assault with a deadly weapon, which I'll talk about in a minute, caused the death of Landa Diane McIver, a human being, by shooting her with a handgun. Count 3 charges Mr. McIver with aggravated assault with a deadly weapon, and the allegation is that the defendant here in Fulton on September 25, 2016, did unlawfully commit an assault upon the person of Landa Diane McIver by shooting her with a handgun, that handgun being a deadly weapon. Count 4 charges the defendant with the crime of possession of a firearm during the commission of a felony. And the allegation is that here in Fulton on September 25, 2016, the defendant did unlawfully have on and within arm's reach of his person a handgun during the commission of at least one of the following felonies: murder, felony murder, and aggravated assault with a deadly weapon. Count 5 charges the defendant with influencing witnesses, and the allegation is that on or about September 25th, 2016, the defendant did unlawfully and knowingly engage in misleading conduct toward Patricia Diane Carter, specifically by instructing Patricia Diane Carter to tell law enforcement officers that she was not present when he shot Landa Diane McIver with a handgun. And it is alleged that this was done with the intent to prevent the communication to a law enforcement officer, prosecuting attorney, or judge of this state information relating to the commission of a criminal offense. And that this instruction, this purported instruction to Patricia Diane Carter, related to an official proceeding intended to be effected in Fulton County. Count 6 also charges influencing witnesses, and the allegation is that here in Georgia, on the 30th day of September 2016, the defendant did unlawfully and knowingly engage in misleading conduct toward Charles William Crane, specifically by instructing Mr. Crane to retract a statement made to him by the defendant, which was previously published to the news media on the defendant's behalf by Mr. Crane. And it is alleged that this was done with the intent to prevent the communication to a law enforcement officer, prosecuting attorney, or judge of this state information relating to the commission of a criminal offense. It is also alleged that this instruction to Mr. Crane related to an official proceeding intended to be effected here in Fulton County. And finally, count 7 alleges a third count of influencing witnesses. The allegation is that on October 6, 2016, the defendant did unlawfully and knowingly engage in misleading conduct toward Patricia Diane Carter, specifically by leaving a voicemail statement with Patricia Diane Carter's husband, Thomas Lee Carter Jr., in which the defendant implied that Patricia Diane Carter ceased communicating her recollections of the facts and circumstances of the death of Landa Diane McIver to law enforcement officers. because these statements place the defendant at imminent risk of immediate incarceration. It's further alleged that Mr. McIver requested Thomas Lee Carter Jr. to delete the voicemail, and that all of this was done with the intent to prevent the communication to a law enforcement officer, prosecuting attorney, or judge of this state information relating to the commission of a criminal offense. And finally, it's alleged that this instruction related to an official proceeding intended to be effected here in Fulton County. Ladies and gentlemen, what I just read to you is not evidence of anything. In particular, it is not evidence of guilt whatsoever. It is, as I told you way back when, the formal charging document. It's how charges are brought in Georgia. You should not consider these charges as evidence or even an implication of guilt of any crime whatsoever. The defendant sits before you with a presumption of innocence in his favor, and his presumption stays with him unless and until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. A defendant should not be convicted of any crime until that crime charge and each element of it is proven beyond a reasonable doubt. This burden of proof, beyond a reasonable doubt, rests with the state throughout the trial. It never shifts to the other side. This does not mean, however, that the state is required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. Rather, the state's burden is to prove the defendant's guilt, as I've mentioned now several times, beyond a reasonable doubt. And that phrase means just what it says. It's a doubt based upon common sense and reason. It's not a vague, arbitrary, or capricious doubt. It's not a speculative doubt. It's a doubt for which a reason can be given, a reason that arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. And the defendant, who is, as I have told you, presumed innocent, has no burden of proof whatsoever. There will be no point during the trial where I stand up and say, okay, the state's met its burden, now it shifts to the defendant. It may be that his attorneys don't say another word during the course of the trial because they have no burden on his behalf. I expect you'll hear from them, but they're not required to do anything at all. The burden is exclusively on the state. If, after giving careful consideration to everything you've seen and heard, all the evidence in this case, you find that your minds are wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit the defendant. But if no reasonable doubt exists in your mind, you would be authorized to convict. The trial is going to begin in a moment with opening statements. Both sides will have the opportunity to make opening statements. Opening statements are not evidence. In fact, and I'll repeat this several times, nothing that the lawyers say in this case is evidence. What the lawyers say during their opening statement is a forecast or a preview of what they believe the evidence will show, what they expect it to be, or what it won't be. Following the opening statements, the state will begin the presentation of its case in chief, and they'll do that by calling their first witness. Every witness will be sworn in to tell the truth, the whole truth, and nothing but the truth. When that witness answers the first question, will come from the state, that answer is the beginning of the evidence in this case. Evidence can come to you in the form of the oral testimony given by witnesses, as well as physical evidence, exhibits that are admitted and will be numbered, most of which will likely be made available for you to examine during your deliberations. So evidence comes from witness testimony and the exhibits that are admitted, not what the lawyers say or what I say. After the state rests, in some ways down the road, I'll ask the state to call your next witness. And one of the attorneys will say, Judge, at this point, the state rests. You all will get a break. We'll take some things up. And if the case is still going, the defense will have an opportunity to present evidence if they choose to. No burden on the defense. So it may well be that all we hear from the defense is the defense rests. They're not expected to or required to present anything at all. But they have the absolute right to do so should they choose to. After the presentation of all the evidence, meaning both sides have rested, and if there's any rebuttal, we've heard all that rebuttal, then the attorneys get to get back up in front of you and give what's called a summation or closing argument. That's when the attorneys argue to you what they think the evidence has proven or has not proven. This is an effort to persuade you to decide the case in one direction or the other, and it's perfectly appropriate for the lawyers to try to persuade you. But just as with the opening statements, what the lawyers say in their closing is not evidence. A lawyer standing up in front of you and say, by golly, you heard witness X say Y. The lawyer could say it 20 times. That doesn't mean that the witness actually said Y. Or it doesn't mean that you should decide something just because the witness said Y. You all decide what was said, what the evidence is, and what the facts are in this case, after you've heard everything. When the attorneys are done with their closing arguments, I will give you a more detailed charge as to the law that you must apply to the facts as you find them to be. And it's during that charge that I'll give you the elements of these crimes. What are the elements of murder and felony murder and aggravated assault? You don't have that now, but you'll get that before you begin your deliberations. Then, and only then, after I've given you the charge, will you all retire to the jury room to actually begin your deliberations. What that means is between now and that point, it's not appropriate for you all to start deliberating. So over lunch say, well, I'm already leaning this way or that way. You're going to feel what you feel, but you don't share that with your colleagues because you don't have everything until I'm done giving you the law. You'll have all the evidence once both sides rests, and you'll have the efforts to persuade you once the closings are done, but you don't even have the law. You don't know what elements it is the state needs to prove beyond a reasonable doubt. Now, during the trial, the attorneys for both sides have a right to object to the admission of evidence if that particular side believes that the admission of the evidence would violate some rule of evidence. This you've seen on TV. An attorney may stand, may just say from his or her place, objection, may add some words to it. I have to rule on these objections. If I sustain the objection, that means that whatever the side asking the question was trying to do, they need to do something different because the way they were going was inconsistent with some rule. If I overrule the objection, then the party asking the question can keep on going. I said that objection is misplaced. I'm not granting the objection. Now, it's important that you limit your consideration to only the evidence that it is admitted at trial. I mean that in two big ways. The big one we've talked about is no outside research, but that's not the point I'm making right now. It may come to pass during the trial that an objection comes up only after a witness started to answer a question. The question may have been innocuous, and so there's no objection. But then the witness starts to say something that's inconsistent with the rules of evidence. And so an attorney may get up and say, objection, X, move to strike, or ask that the jury disregard what they just heard. If that happens, and I tell you all to disregard what the witness just said, and I'll usually, because it could be the witness spoke for 4 minutes, I may say you need to disregard what the witness said about what the temperature was outside. I mean it when I say that. And so if you wrote it down, cross it out. And should you recall during deliberations that moment, and one of your colleagues during deliberations says, hey, remember when that witness was talking about what the temperature was? You need to play police person and say, I do, but we're not considering that. The judge said we're supposed to disregard that. Fortunately, that doesn't happen all that often. We've got great lawyers, and they can usually tell, just based on the question, if there is a potential issue there. But sometimes witnesses answer more broadly than just what the question asked. And so if I tell you to disregard something, it's important that you do that. Objections we can typically handle right there on the spot. I can overrule or sustain the objection. Sometimes attorneys may have motions. Those are more complicated and often require you all to take a break so that I can let the attorneys speak more freely about what their concern is. And it could involve something that we've been working on for days before you even got here, and we need to revisit things we talked about outside your presence. We try to work through those things during your breaks, lunch, before you get here, after you leave, but unexpected events can occur, and if an attorney has a motion that I feel can't be deferred to one of the breaks, I may ask you all to go back into the jury room and we'll work as efficiently as possible to tackle that without making you wait around too often. But these things happen, and I do need to work through them so that I can get a ruling to the parties. Now, in my rulings on objections and motions, it's important that you understand that nothing I say now in making a ruling or at any other point is evidence of anything. You should not interpret anything I say as an indication that I'm leaning for one side or the other. If I rule in favor of an objection, all that means is that the rules of evidence don't allow whatever the other side was trying to do. It doesn't mean I favor one side or the other. It's sort of like calling balls and strikes. You know what? That is hearsay. We can't go that far. I mean, that's speculation. So over it's sustained, you need to go in a different direction. My sole interest in this case is to make sure that it is fairly tried according to the laws and Constitution of Georgia and the United States. I am otherwise completely objective. Now, you all have a role in this process as well. We've talked about the lawyers. We've talked about my role. You are the fact finders. You decide what happened in this case. And you'll apply the law that I give you to the facts as you find them. And you'll decide the facts based upon the evidence, witness testimony, and physical exhibits that are admitted. In doing all this, you will necessarily be determining the credibility or believability of the many witnesses you'll be hearing from. And in determining credibility, you are free to consider all of the facts and circumstances of this case, as well as the manner in which the witness testifies, your observations of what the witness is doing while he or she is answering the questions, your perception of the witness's intelligence, interest or lack of interest in the outcome of the case, and the means and opportunity that the witness has for knowing the things the witness is talking about. Now, in fulfilling your role as fact finder, you all may from time to time have questions that are not addressed through the questions of the attorneys. The way we work through that is that stack of note cards sitting in front of the jurors on the first row. During the course of the examination of a witness, if you have a question, you ought to write it down on one of those cards. When both sides have had a chance to examine the witness, I'll ask you all, if you have any questions, to pass those to Deputy Murphy or one of his colleagues. I'll review those questions, and the attorneys will get a chance to review those questions. The purpose of the review is just like attorneys can ask questions that are objectionable or problematic, so too can jurors. So you should draw no conclusions or inferences if you write down a question and it is not posed to a witness. It just means that wasn't an appropriate question. But if they are proper questions, after the attorneys have had a chance to review them, I'll pose those questions to the witnesses. Remember, it's only what the witnesses say that is evidence, not questions. So if your question isn't asked, that does not evidence anything other than there was an evidentiary issue with that question. And the lawyers will be free to follow up if there are any questions submitted by jurors that I pose. The attorneys will have a chance to follow up from that. Now, it's essential throughout the trial that you pay close attention to what's going on. As I told you when we were talking about notepads, there's no rewind button. So if you feel yourself starting to fade and it's time for a break, let Deputy Murphy or me know. You can raise your hand. If you can't hear because a witness is soft-spoken or there's an attorney in the far corner of the courtroom demonstrating something far away and you can't see it or hear it, right away let us know. That's not a problem. The reverse. It is a problem if you can't see or hear or you're losing focus, and we need to address it. Addressing it could be telling someone to speak up. It could be giving you an opportunity just to stretch. It could be you need a 5-minute break. We will break as often as you all need to break. We're just not getting stuff done while we're taking breaks. But you all need to be as focused as can be. So please keep me posted if that ever changes. It's essential that you view the evidence in this case with an open mind and reach no final conclusions until you've heard and seen all the evidence, received closing arguments, and received the law that you must apply to the facts of the case. That's when your deliberations begin. Now, I'll repeat this many times, but it's worth it. It's essential that your decision in the end is based only on evidence that's presented here within this courtroom. evidence presented where both sides were there to see it and hear it and lodge objections if they have any. That's why there's no outside research. If you had a group making an important decision for you, you'd want to know what information they have, and you'd want to be involved in the process of ensuring they got information that was consistent with the rules of evidence and not outside information. So please, no outside research, and maintain that buffer that you've begun to build around you so that people don't talk to you about the case. For those of you who are active online, this is a corollary to what I just said. It's important that you minimize your broadcasts about what's going on, because well-meaning people could respond. You could tweet or put something on Facebook saying, "Another day in the salt mines," and someone could write back, "Hey, actually today sounded interesting because I read ... and then you would be receiving sort of third-hand, even more questionable information, because it's filtered through the media and then filtered through your friend who put something on your Facebook page because you put something on your Facebook page about what's going on in the trial. So please do your best to limit that type of outside contact. Obviously, you can talk with friends and family, employer if necessary, about the fact that you are in a trial. They all know about it anyway. But the day-to-day of what goes on isn't something for you to talk about. You can say it was a long day, a short day, judge had a nice tie, whatever, but not about the substance of what's going on. Do know this: when the trial is over, you will be free to do whatever you want. You want to write a song about it, you can write a song about it. You want to make a dance about the trial, write a book, you can do that. But that's not until the trial is over. Then all holds are released, and you're free to talk to anyone and everyone about whatever you want about this process, but not until the trial is over. Ladies and gentlemen, that is what I have to share with you. We're about to start opening statements. A couple things about the logistics. This ginormous screen here will be here for opening. It may come back later, but then it's going to go away. I can't see you very well. I'll sit here during opening, but with it there, it's hard to see you. It's hard for you all to see further into the courtroom. It may come to pass during the opening or during the course of the trial that there'll be actual, real guns in the courtroom. They cannot get into the courtroom unless they've been secured by law enforcement and there is no ammunition in the gun. So don't panic if a gun is presented to you at any point during the trial. They've been secured, and they may well look different than they did at the time the gun was acquired, however the gun was acquired, because there could even be a big old piece of plastic through the receiver and whatnot to demonstrate that it's secure. I don't know exactly how they're processed, but I just wanted you to know that for the firearm to be handled by the lawyers and presented to you all, it has to have been made secure. At this time, if the state's going to give an opening, we can begin. Sure. Thank you, Mr. Harvey. If there are any potential witnesses, with the exception of the folks that I addressed yesterday in dealing with Ms. Counts, her motions and the motions from the Kilpatrick Stockton attorney, you all can stay here. Otherwise, if you have received a subpoena to testify, or you've agreed with one side or the other that you might testify, it's time to step outside. And I will rely on the attorneys and investigators for both sides to keep watch as well. A witness could inadvertently walk in because they're soon to testify. They need to stay out until they're called. When you're ready, Ms. Griffin.
Good morning, everyone. Good morning. I am Felita Griffin, Chief Senior ADA assigned to the Major Case Unit at the Fulton County DA's office. And along with my esteemed colleagues, Mr. Clint Rucker, Ms. Kara Convery, Mr. Adam Abadi, and Ms. Siri Elamjaru, it is an honor to represent Diane McIver, the citizens of Fulton County, and the state of Georgia in the prosecution of this case. The defendant in this case is charged with 7 counts in the indictment. Counts 1 through 4 encompass the murder of Diane McIver. And counts 5 through 7 are about the influencing of witnesses to cover up what he did to her. Now, this is a case about maintaining an image of wealth and power that the defendant created for himself and the lengths that he went through to keep it. Now, I'll give you a little bit of background about the relationship between Diane McIver and the defendant. Now, they were married in 2005, and this was the second marriage for both of them. And they were both successful in their own right, and they decided to keep their finances separate. The defendant was a partner at Fisher & Phillips, which is a large law firm with many offices across the United States. And he had been there for 40 years and was making a nice living for himself. The defendant was politically influential. He sat on a lot of boards and committees and was very active within the community of Atlanta and Putnam County. Diane McIver started as a bookkeeper at Corey Company, and she worked her way up to become the president and CEO of U.S. Enterprises. And you will hear from witnesses that Diane was a shrewd businesswoman, and her knowledge and expertise propelled U.S. Enterprises into a multi-million-dollar company. And in addition to her role at U.S. Enterprises, she owned 3 other companies: Clay Management, DRS Investments, and Diane Smith Interiors. And at the time of their marriage, she was worth $12 million. Diane was very career-driven, and she never had any kids. But she had a godson named Austin that she loved dearly, and she was a very active part of his life from the minute that he was born. The McIvers had it all. They had this lavish condo up in Buckhead, decked out with the most expensive and extravagant things that Diane could find. And they had this sprawling ranch out in Putnam County. It sat on over 60 well-manicured acres of land. It had a guest house, a saloon, horses and cows. It was beautiful. It was picture perfect. The McIvers had the storybook life. And you'll hear from witnesses that they never argued, that they never saw them argue, that they thought that everything was okay. But things weren't as they seemed. And on September 25th, 2016, the day that the defendant shot his wife in the back, his life was spinning out of control. The partnership that he had in 2005 at Fisher & Phillips was gone. He lost his partnership in 2014 and was planning on retiring in December of 2017. And over the 3-year period, his salary dropped 54%. But what the defendant did is he attempted to maintain the same lifestyle with the same expenses and less money. Now, I said earlier that the McIvers kept their finances separate. And the evidence will show that Diane McIver was responsible for taking care of everything in Atlanta. She took care of the expenses for the condo, the utilities, the association fees, everything that dealt with Atlanta. That was Diane McIver's responsibility. And the defendant was responsible for taking care of the ranch out in Putnam County, including feeding the horses, the cows, the utilities, paying Javier, their ranch hands. All of those expenses were his, and they were running about $20,000 per month. He had become dependent upon Diane. And over the 3-year period from 2013 to 2016, our financial expert, Mr. Dean Driscoll, will testify that he received $198,000 from Diane McIver. In addition to the $198,000 that he received from her, she gave him a loan for $350,000 in 2011. This wasn't a, hey, you can pay me back whenever you get the money. This was an actual loan with a promissory note. And the loan was secured by the ranch out in Putnam County. And based on his financial condition, the defendant would not be able to repay this loan. In fact, the evidence will show that in 2011, when she gave him the loan, it was due in 2014, and he hadn't paid it. So she renewed it, so that it will be due in December of 2017. And the evidence will show that over that period, he made interest-only payments and never paid any money on the principal. Diane had told Ann Schwall, the mother of Austin, that she was going to leave the ranch to her godson. And Diane loved Austin so much, she would never draft a will without Austin being included in it. And the evidence will show, we will have Mr. Carlton Morse, expert in real estate, testify that unless Diane McIver foreclosed on the ranch and took control of it, she couldn't leave the ranch to Austin. The evidence will show that Diane could take control of the ranch by foreclosing on it if the defendant did not pay. The defendant did have a pension, and our expert would testify that based upon his spending habits, it would be depleted in 2 years after he retired. And in addition to that, without the money from Diane that he was receiving every month, on the time of her death, the defendant wouldn't even have $1. As a matter of fact, without Diane's money, on the day that she died, his account would have been negative over $5,000. You're going to hear that when she drafted the will in 2016, the ranch would go to the defendant. If she foreclosed on the ranch, it was her intent for the ranch to go to Austin. And you're going to hear in the days after Diane was shot, and the defendant goes to talk to 2 homicide detectives at APD. And without any prompting, he tells them, "I like to be in control." And on September 25th, 2016, Diane was making all of the money. Diane owned the 2 condos in Buckhead. Diane could take the ranch. This ranch, according to the witnesses, that was his pride and joy. This ranch that he would go to every weekend, that he would host parties at, that he would go shooting at, Diane could take from him. On Diane's death, he went from negative $5,000 to over $1.1 million cash instantly. And he was the executor and one of the beneficiaries of Diane's $7 million estate. The easiest way for him to gain control was to kill Diane. And on Sunday, September 25th, 2016, the evidence will show that that is just what he did. The day started off in Putnam County, and they went golfing out at Reynolds Plantation. And it was Diane McIver, the defendant, and one of her co-workers, Mr. Craig Stringer. And Danny Joe Carter, one of Diane's longtime friends, had went and spent the weekend out at the ranch with the couple, but she didn't go golfing. After they went golfing, they came back to the ranch, picked up Danny Joe Carter, and then they went to have dinner at the Longhorn Steakhouse in Conyers. During the dinner, Diane McIver and the defendant had something to drink, so Danny Joe Carter was driving the truck. They were in a huge white Ford Expedition. And Danny Joe was driving. Diane McIver was in the front passenger seat. And the defendant was seated right behind her. And as they're taking 20, going towards Atlanta, As they approach the downtown connector to go 75-85 north to head to Buckhead, traffic stops. And not wanting to sit in traffic, Danny Jo Carter takes the first exit that she could. And that would be the exit off of 75-85 at Edgewood Avenue. Once she takes that exit, she makes a left onto Edgewood Avenue, goes about 3 blocks, and then she makes a right on Piedmont. Danny Jo Carter will testify that she really wasn't paying any attention to the defendant. And after they exited on the highway, he asked for his gun. And Diane McIver opened the console and picked up a gun that was in a plastic Publix bag, handed it to the defendant, not knowing that that would be the weapon that ended her life. She says that Danny Jo Carter would testify that as they're heading down Piedmont, her and Diane are talking, and she's not really paying any attention to the defendant. She'll testify that she remembers crossing over Ponce, she remembers going straight over to 10th Street, and she remembers that either at 12th Street or 14th Street, as she's sitting at a red light, she hears a gunshot. Diane says, "Tex, what did you do?" She looks back and she sees and she sees the defendant sitting in the back. She sees a puff of smoke, and she sees him in the back with this gun in a plastic bag, and he's moving it around. And then she looks back over at Diane. And she says Diane is writhing in pain. And she says, "Tex, I think you shot me." And then she keeps moving around, and then she loses consciousness. Danny Jo is panicking. She is freaked out. She had never been in a situation like this before. And in her mind, she's thinking that Piedmont would be the closest hospital to take Diane McIver to. But she can't remember how to get there from where she is. So the defendant tells her, "Let's go to Emory." And she'll testify that she says, "I don't know how to get there either." And he says, "I'll give you directions." So she presses the gas, starts honking the horn because there are cars in front of her trying to get around. And she's driving as fast as she could. She goes past Ansley Mall, makes that right on Morningside, and she's going down that road zooming, running stop signs, running red lights. And the Morningside area is a two-way street. And it was dark. And she was trying to do the best that she could for Diane. Now, the time that it took to get them to Emory, due to discrepancies in the cameras, it will not be precise. But what we do have is that Danny Jo remembers is that it took 10 to 15 minutes for them to get to Emory University Hospital on Clifton. And another thing that she remembers is that as they're driving back there on Morningside, it turns to East Rock Springs Road, and they're getting closer to Emory. They're approaching a roundabout, and she's driving as fast as she could. And she says the defendant comes up to her, and he tells her, "Slow down." slow down. There may be women walking their babies in baby carriages at 10 o'clock at night. She'll tell you that she pays them no mind, and she keeps right on to Emory Hospital. And they get there, and you'll see that they come up to the valet, and at some point the defendant gets out of the truck, and you'll see him walking casually up to the entryway. And you'll hear testimony that he says, gunshot wound. And ladies and gentlemen, somehow the defendant wants you to believe that the death of Diane McIver was an accident. But ladies and gentlemen, this was no accident at all. And the evidence will show that this was indeed murder. All of the events on September 25th, 2016 by the defendant were planned, intentional, and calculated. And we'll start from putting the gun in the plastic bag. Our expert will testify that the result of putting a gun in a plastic bag and shooting it prevents gunshot residue from getting on your hands and clothes. In addition to putting the gun in a plastic bag, 8 hours before the murder, the defendant asked Tanner McKinney to take Danny Joe Carter back to Atlanta. Now, Tanner McKinney and Samantha Watson are two young adults that come out to the ranch on a couple of Sundays out of the month in order to groom the horses and to walk them or to ride them. Tanner will testify that he lives in Athens. And he'll testify that he remembers the defendant asking him this because he knew that Danny Joe Carter lived in Atlanta. So he was confused by the request of the defendant to take Danny Joe to the opposite side of where he lived. In addition to that, our expert, Michael Knox, who is a crime scene reconstructionist and an expert in ballistics and firearms, recreated this crime scene. He took measurements, photos, and he recreated the circumstances of that night. And based upon the trajectory of the bullet and the injuries to Diane, he concluded that the gun was aimed at her back. It wasn't on her lap. It didn't accidentally discharge. It was aimed right at her back. The gun that was used, the .38 revolver, was in perfect working condition. It was tested by the GBI and Michael Knox. They fired it, and they did other testing on it to determine that it had no hair trigger. In double action, it required 12 pounds of trigger pull for it to fire. And in single action, it was 2.5 pounds. Michael Knox determined that the revolver could not be fired accidentally, that the defendant had to intentionally pull the trigger, and it couldn't just go off. During a search of the condos in Atlanta and the condos in Atlanta and the ranch out in Putnam County, 44 guns were seized. Some of them belonged to Diane, but a majority of the guns belonged to the defendant. And there were handguns seized, including revolvers and semi-automatics, rifles, shotguns, and a poker gun. And Tanner McKinney and Samantha Watson will also testify about how the defendant demonstrated to them how to use that gun. And what they'll testify about is that he showed them the gun after a tour of the ranch. And he told them that in order to fire the gun, you had to know all of the special steps to get it to fire. And that he was the only one that can operate the gun, and he showed them how to do it. The defendant had a makeshift firing range at the ranch. It was a huge mound of dirt back in the back. And you will hear witnesses testify that he would go back there and shoot all the time. And he lectured others about gun safety. He would take Austin back there and shoot, and a number of other friends. And they will testify that over and over again, he would lecture them about gun safety. And you'll also hear Danny Joe Carter tell you about a time when a defendant threw a water bottle up in the air, shot it 2 times before it hit the ground. In addition to the gun being in perfect working condition, at the time of the incident, there was no 911 call. The defendant was seated in the back seat, and right beside him, within arm's reach, was his cell phone. And then right beside that on the seat, in her purse, was Diane's cell phone. And right beside that, also within arm's reach, was Danny Joe Carter's purse. And in her purse was her cell phone. And the evidence will show that none of these phones called 911 on that night. Once the defendant got to Emory, people started asking questions, and the nurses and the staff wanted to know what happened to Diane McIver. And you will hear that over the course of time, the defendant gives 6 different versions of what happened to Diane McIver in the car that night. You will hear from 3 doctors and about 8 nurses from Emory University Hospital. And none of them knew anything about Diane McIver or the defendant or Danny Joe Carter. You'll hear from Dr. Celine Shabler. She's an emergency room doctor. And you'll hear that on that night, when Diane McIver came in, she was actually getting off of work as the attending physician in the emergency room. And Dr. Suzanne Hardy was taking over. But since Emory University Hospital rarely deals with gunshot wounds, she decided to stay and help. So as Dr. Hardy was working on Diane McIver, she was doing little things for her. Like she went and ordered labs and did things like that. Would come back and get updates for the defendant. So one time after she went to talk to Dr. Hardy and asked her how was Diane McIver, and she told her that they were working on her and to go see how the defendant was doing. So she walks to the family consult room, and the defendant is sitting in there alone. And they're talking, and she asks him what happened. And what he tells her is that they were driving in a bad neighborhood, and Diane asked for the gun. And she reached in a console and got it. And then she took the gun and she put it behind her back. And as they were driving, it went off. And that's how she got shot in the back. Then he told another nurse that as he was cleaning his gun in the bathroom, it went off and shot Diane in the back. And on this same night, he told another nurse that the gun went off while he was holding it in the back seat, and that's how Diane was shot. You're going to hear from Dr. Suzanne Hardy, who was the treating physician of Diane McIver. And as she's working on Diane, she's trying to figure out what happened. Because at this time, she saw 2 holes in Diane. One in the front and one in the back. And she was trying to determine, was it 1 gunshot wound or was it 2? So she asked Diane what happened. And Diane says, I was holding it behind my back when the gun went off. Dr. Hardy will testify that she thought this sounded odd, so she asked her again, you were holding the gun? And then Diane says, he was holding it behind my back. Then about 30 seconds pass, and Diane states it was an accident. Dr. Hardy continues to work on Diane and continues to try to save her life. And as time passes, she knows that Diane isn't doing so well and that she might not survive. And she'll testify that Diane looked at her and was like, I'm dying. And not wanting to tell her the truth, what she did was she said, we're doing the best we can. You're getting the best care possible. But at this point, I'm going to need to intubate you. And to intubate is to put a tube down her throat. And she was like, after I put this down your throat, you won't be able to speak. And what she does is she asks Diane a question. She asks Diane, do you want to see your husband? And Diane says, no. While the defendant was telling all of these stories and trying to change the narrative of what really happened, he had one big problem, and that was Danny Joe Carter. And the evidence is going to show that after they arrived at Emory, what he did was he told Danny Joe, these situations can get a little bit crazy. So why don't you tell the police that you were not in the SUV tonight and that you just arrived at the hospital sometime later? And Danny Joe told him, I'm not doing that. I'm not going to say that because that's not true. And in addition to trying to get her to lie at the hospital, he also pressured her to hold a press conference to proclaim his innocence. And she didn't want to do that either. And what he did was he sent a car to her house to pick her up. And what Danny Joe had done is her and her husband, Tom Carter, left. And they went to the home of Dale Cardwell. And some of you may know who that is. He's a TV personality. He reviews businesses. And they went to his home. And he'll testify that when they got there, Danny Joe was upset. And when the defendant couldn't get a hold of Danny Joe, he repeatedly started calling Tom Carter. He's calling and calling and calling and calling. He's blowing up his phone. And he leaves 3 messages. And one of the messages, he tells Tom to tell Danny Joe to stop saying what she's saying because it could end him up in jail. And what he tells him is after you listen to this message, delete this message. And you'll hear it. In addition to trying to get Danny Joe to do this press conference, he also called his longtime friend, Mr. William Bill Crane, who's a TV personality, talks about political issues on TV. And they have been friends for about 33 years. So he calls him to be his public relations specialist for this issue. And so what he does is he wants to get his side of the story out to the media, because at this time the media is starting to speculate about what happened. And so what he tells Bill Crane is that as they're exiting at Edgewood, and they turn under Edgewood, and they're going under the overpass, He asked for his gun because he believes that the truck may be attacked by either some Black Lives Matters protesters or some homeless people. And he says that's why he asked for his gun. And then once they got into Piedmont, or a safer area, he dozed off and went to sleep. And then as they were going along, they hit a bump, and the gun went off. And that's how Diane got shot in the back. So Bill Crane would testify that he wrote the story down, sent the version over to the defendant, said, is this all right? Is this what you want me to release? And he got the okay. And then what Mr. Crane did was start distributing it out to media outlets. And once the story got to the media, there was a big backlash about it. And the defendant's attorney at the time, Mr. Steve Maples, and the defendant started calling Bill Crane and asking him to retract the story. They asked him to say that he misrepresented what the defendant said, and that the defendant had never actually said that. And he refused to lie for the defendant. And as a matter of fact, the day before he gave the statement to Bill Crane, he had went down to talk to two APD homicide detectives. And when he gave them a version of events, he said that he asked for the gun because they were in a bad neighborhood, and then he fell asleep. He was in a twilight type of zone when he woke up, and then the gun just went off. And never in that version did he say anything about Black Lives Matter or a bump. After Diane McIver died, less than a week after she died, the defendant began to inventory all of her belongings. Her jewelry, her clothes, her hats, shoes, everything that she had, he began to inventory it so that he could sell it. And what the defendant told media outlets and journalists is that he was doing this in order to satisfy the bequests in her will. And he had an estate sale and an auction and raised over $187,000. And the evidence will show that to this date, not one of those bequests have been paid. In Diane's will, she desired to be cremated. And you will hear evidence that after her autopsy on September 26th, she was transferred to Phoenix Funeral Services to be cremated. And that she was cremated on September 29th. After she's cremated, Miss Wendy Edson, the owner of the crematory, calls the defendant and says, hey, you could come and pick up your wife. He doesn't show. She calls back and says, hey, you could pick up your wife. And what he tells her is that he has to wait for the estate to start being probated so that her estate could pay for her cremation. And so another week passes, and another week. And on October 28th, Diane McIver is still down at the crematory. And one of her friends from a long time ago, Miss Kathy Johansson, learned that Diane was down there, and she paid for it anonymously. And all she asked for was one small memento of Diane. And it wasn't a $5,000 fee. It wasn't a $4,000 fee. It was $1,600 that she paid to get the remains. And it doesn't stop there, ladies and gentlemen of the jury. When all of this other stuff that he was trying to do didn't work, what he did was, after he fired Bill Crane for not retracting the story, he hired Mr. Jeff Dickerson. Now, Mr. Jeff Dickerson is also a public relations specialist. And he's been in the business for a long time. You all may know him from seeing him on Sundays as part of the Georgia gang. And what you will learn is that Mr. Dickerson was a longtime friend of my boss, Mr. Paul Howard, over 20 years. And what he'll testify to is that after he was hired by the defendant, he was called down to his lawyer's office. And the defendant and his lawyer were sitting at a table. Then the lawyer gets up to leave. And it's just the defendant and Mr. Dickerson. And what he tells Mr. Dickerson is, you can get this case dismissed. You can get this case dismissed. And if you do, there's a large bonus in it for you. And I won't mind if you share it with the DA. Now, ladies and gentlemen, at the close of all of the state's evidence, Mrs. Kara Convery will get up here, followed by Mr. Clint Rucker, and they'll perform closing arguments. And what the state will ask you to do is to return a verdict. And the only verdict that speaks the truth in this case is a verdict of guilty. Thank you.
Thank you, Ms. Griffin. Mr. Clark Palmer, tell me what you'd like the state to move so you have the well as you'd like it. Sure. So we need the big TV moved against the wall, please.
Your Honor, I think I might go until sometime of that one, so I don't know if anybody wants to break now before I start.
Okay. If we take our first break at 11 today, everyone okay with that? I'm getting lots of nods, so we're good to go.
Thank you.
You bet. Ms. Nelson? Sure. Ms. Clark Palmer, you ready?
I am, thank you.
Okay. This is the opening from the defense.
Thank you, Your Honor. May it please the court, state, defense, and Mr. McIver. Good morning, ladies and gentlemen. My name is Amanda Clark Palmer. We just spent, I think, maybe 30 or 40 minutes listening to the state tell you all their theories and their reasons why they think Mr. McIver intentionally shot Diane McIver. And I want to tell you that you can just set all of that aside. There's really one thing that you need to know about Tex McIver and Diane McIver to know that he did not intentionally shoot his wife, and that is that he loved her. Truly loved her, deeply loved her, and she loved him back. You are going to hear from multiple witnesses that they had a relationship that people were envious of, that they seemed like lovebirds even after 10 years of marriage, that Tex adored Diane, that she loved him, and that they were clearly proud to be married to each other. And that's why he didn't intentionally shoot her. So, I'm sorry, Your Honor, this TV is not on. I didn't realize that. So the jurors cannot see my...
Hold on a second.
Okay, thank you.
I can reach it.
Did you get that on film? Is it on now? I hope so, because that hurt.
Thank you. Okay, so there are some facts that we don't dispute in this case. Actually, maybe quite a few. One fact you are not going to have to decide is, did Tex shoot Diane? Yes, he did. We are not telling you that the gun was sitting on the seat next to him and it accidentally went off. We are not telling you that the gun malfunctioned. No one is going to ask you to decide who was holding the gun when it went off. It was Tex. That's not a dispute, so don't worry about that. The question you have to decide, was it intentional? And the evidence is going to show it was not. Nothing the state will present to you will prove that this was not an accident. So let me start by kind of going through the timeline of September 25th. And again, this is an area where probably we don't have a lot of disagreement with the state. Danny Jo Carter and Diane and Tex drove out to their ranch in Eatonton, Georgia, which is near Waco County, on Friday, September 23rd. They all went out there together. They had a wonderful weekend. They had great weather. On the afternoon, the day in the afternoon of Sunday, September 25th, Tex and Diane played golf. They had a great round of golf. I think Diane beat Tex. She was an excellent golfer. Danny Jo was riding horses. And after they got done playing golf, it was kind of in the late afternoon, evening, and that was when it was time to head back to Atlanta. So they leave the ranch. They stop off at the Longhorn in Conyers, where they meet Craig Stringer, who is a co-worker or colleague of Diane. I believe he had also been playing golf with them earlier that day. He meets them at the Longhorn restaurant, where, yes, they share dinner. And by the time they leave, I think you'll hear that it was maybe approximately 8:30 at night on Sunday when they left. So they start driving back to Atlanta. The state showed you part of the route that they used to drive back to Atlanta. Again, a fact that's not in dispute. They go on I-20, and when they get to the connector, they hit a traffic jam. There was some construction going on the interstate, so traffic was really backed up. At this point in time, Tex has fallen asleep in the backseat of the car. He fell asleep on the ride from Longhorn into the city. And so Diane is the one who tells Danny Jo to get off the interstate. Diane is familiar with that area down there. She knows how to use the surface streets to get from the Edgewood exit area back up to their condo in Buckhead. So she is giving Danny Jo the directions. They get off at the Edgewood exit, as I say, and at that point in time, Tex wakes up. And he looks around. He says, "Girls, I think this is a bad idea," or "I think this is a bad area," something like that. And he says something to the effect of, "Darling, why don't you hand me my gun?" And as the state said, Diane reaches into the center console. The gun is already in the plastic bag. Mr. McIver doesn't put the gun in the bag. That's how it was stored in the vehicle. It was stored that way to sort of disguise it in case somebody broke into the car. The thief wouldn't realize that it was a gun, hopefully, and take it. So it was already in the plastic bag. That's how it was stored in the car. Mrs. McIver passes it back to him. He's in the back seat of the car. He's kind of, sitting back there, puts the gun in his lap. He's, maybe slumped down a little bit. And as they start to drive and keep going, he throws his back out all back seat. Now, when Diane McIver and Danny Joe pass the gun back, they don't object. They don't say, Tex, what are you talking about? You don't need your gun. What do you need that for? They just hand it back to him. No questions asked. So when they get up to the area of Piedmont Park, as the state said, the gun discharges. At that point in time, and I'll get to this a little bit later in more detail, the gun is in Tex's lap. Okay? It's kind of laying sideways in his lap. Like this, he's falling asleep. When they get back to Piedmont Park, the gun just discharges and goes off. And it takes a second for Danny, Joe, and Diane to realize what has happened. I think Danny Joe, I expect that she'll tell you at first she thought maybe somebody hit them in the car. She wasn't exactly sure what the sound was. And Diane says, Tex, what did you do? And then a few seconds later, maybe even close to a minute later, it was a traumatic situation. Nobody had a stopwatch. So all these estimates of what happened when are really people just kind of reaching back in their memory during this traumatic point in time, trying to say, here's my best recollection of what I think happened. But some time passed, again, seconds, maybe up to a minute, and Diane starts to kind of, I don't know about writhe and pain. I believe that what Danny Joe said is that she kind of starts to slump over, and she kind of starts to lose consciousness. And so Tex is in the back seat, and he reaches forward, and he wraps his arms around Diane. He's holding her head in his hands, talking to her, trying to kind of figure out what's going on. She's shot, as the state said, she's shot in her kind of mid to lower back. There's not a lot of blood. It's not, kind of immediately apparent what her injuries are. There's not, kind of blood pouring out everywhere. You're going to see pictures of what the inside of the SUV looks like. You're going to see pictures of what Mrs. McIver looked like at that time. You'll see that there's just very little blood. So they're trying to figure out what happened, how serious this injury is. And Danny Joe says to Tex, where should I go? Maybe she was thinking that Piedmont Hospital was closer, but she never said to Tex, how do I get to Piedmont? We should go to Piedmont. What she says is, where should I go? And Tex tells her to go to Emory Hospital. He's very familiar with Emory Hospital. He had been there recently for some procedure or surgery, and he knows how to get from the Piedmont Park area up to Emory Hospital. So he starts giving her directions as they're going. They rush to Emory Hospital. Danny Joe is driving as fast as she can. It's important to get there quickly, obviously. It's also important to get there, safely, so they don't have a wreck and slow themselves down even further. And as soon as they get to Emory Hospital, I expect that you will see the video from the valet area. You can determine for yourself if Mr. McIver casually walks up to the door of the emergency room hospital, or if he gets out of the car and he's quickly moving, calling out, gunshot, gunshot. And you see the nurses, and there's some security there who come out and meet them at the car and get Mrs. McIver out of the car and take her inside. And as the state told you, she's treated by Dr. Suzanne Carty. It takes some time. They try to get her stabilized. She regains consciousness when she's there. Nobody is going to come in here and tell you what Mrs. McIver was thinking at that time. Nobody is going to be able to tell you why she said what she said. But what she says to Dr. Hardy without any prompting is it was an accident. Dr. Hardy doesn't ask her, do you think it was an accident? Do you think he did it on purpose? She offers, it was an accident. So the state mentioned to you in their opening the fact that nobody called 911. And that's true. Again, that's another undisputed fact. Danny Jo was driving the car. If she thought to call 911, she didn't tell Tex, hey, my phone is back there. Why don't you call 911? Tex didn't call 911. He was giving the turn-by-turn directions to Emory. I don't think you should draw any inference or conclusion from the fact they didn't call 911. The facts are going to show that they got to the hospital that Tex knew how to get to as quickly as they could. And what Diane said to Dr. Hardy is exactly what happened. This was a horrible, horrible accident. So that's September 25th. In the days after September 25th, Tex McIver actually calls the Atlanta police and says, I understand you want to speak with me. I'll come down and make a statement. And he goes down with Steve Maples, which name you heard. That's the lawyer who was representing him at that time. And he talks to Detective Darren Smith. And let me pause here and just address one thing that the state mentioned in their opening. They told you that what Tex said to the detectives was, I like to be in control. And I want to put that comment in context for you. The question to Mr. McIver was talking about how to get down to the ranch on Friday. The detectives were asking him, how did you get to the ranch on Friday? The detective says, did you all go down in one vehicle? Tex says, yes, sir. Okay, that was the expedition. Correct. Detective Smith, okay, did you guys take turns driving down there? Or did some of you drive more than others? Mr. McIver said, I think I drove. Detective Smith said, okay, you're like me. I like to drive when I go. Tex says, I like to be in control. That's the context of that statement. He's just talking about when they drove down to the ranch, that was why he was driving. It's not some nefarious statement he made in connection with explaining what happened on September 25th. So that's September 28, 2016. Importantly, Tex McIver tells Detective Smith exactly what happened. He tells them he was holding the gun when it went off. He tells them Danny Jo was driving the car when he went off. The events that I just relayed to you about what happened on September 25th, that is what Tex McIver told the Atlanta Police Department on September 28th. Months later, in December 2016, he is arrested. He is arrested for reckless conduct and involuntary manslaughter. He is not arrested for murder. So let me talk about the forensic and ballistics evidence. Let me talk about what happened when the gun went off, what the trajectory was. Let me talk to you about the gun itself. And again, this is the gun that went off and shot Diane McIver. As the judge explained, it's made safe, so you don't have to worry about it going off now. I can't demonstrate for you what the trigger pull is because of the lock that's through the gun. But what you'll hear about this gun is it kind of has what I would call two modes: single action mode, double action mode. Some of you who are familiar with firearms may know exactly what I'm talking about, but if you don't, there are kind of two ways you can fire this gun. This is the hammer here. I believe that this is called a shrouded hammer. It's not what I was picturing. When I thought of the hammer of the gun, I thought of something maybe kind of like a sort of an old-timey Western movie, where the hammer's sticking up and it's got the little thumb thing that you click back. This is the hammer of the gun right here. You can see it in the back there. And as I said, it's shrouded, so it's kind of hard to see from the side when you're looking at the gun because it doesn't stick up very far. So if you do not cock the hammer on this gun, you can fire it by pulling the trigger. And as the state told you, it takes about 12 pounds of force to pull the trigger when it is in double action mode. When you cock the hammer on the gun and it's in single action mode, it only takes 2 pounds of force, which is almost a hair trigger. It is getting, that amount of force is so low, it is almost to the point where they can't measure it because it's so light. So the gun can go off very easily when it is in single action mode. There's no way to forensically tell you if the gun was in single action mode or double action mode when it was discharged. No expert can come in here and say, yes, I've examined the gun. I can tell you when it was last fired that the hammer was cocked or not cocked. And again, I want to be clear that the evidence will not show that the gun went off magically or by itself. It was in Tex's lap, in his hand, when it was discharged. So when we say accidental, what we mean is that the shooting wasn't intentional. And I think there are kind of 5 key takeaways you'll see from the forensic evidence that will show to you that this was not intentional. First, as I said, the gun was resting on Tex's lap when it was discharged. Second, it was fired from a sideways position. That's what I was demonstrating for you before, that when Tex was kind of, laid back in the car, sort of slumped down, the gun is in his lap in this sideways position. It's not pointed upright. It's not like this. It's not back by his hip. It is in his lap when it is fired. The gun never comes out of the plastic bag. That is one thing that we can say definitively from the forensic evidence. They can tell that it was fired from within the plastic bag. Fourth, the bullet goes through the seat, and I'm going to show you a slide on that in just a second. And fifth, Diane was shot in her lower back, as I said, mid to lower back, kind of this area back here. So the gun wasn't aimed at Diane. It wasn't pointed, armed, outstretched at the back of the seat. It wasn't aimed higher up her back, where you would expect somebody to aim the gun if they intentionally wanted to kill somebody. It wasn't pointed at any of her vital organs up here, her heart or her lungs. It wasn't pointed at her head through the back of the seat. In other words, all these facts show that the discharge of the gun was not intentional, but was accidental. So we looked at the gun already. So here is what's shown in these pictures is the passenger seat of the Expedition. This picture in the bottom left corner with the number 2 on it, that's the back of the seat. You can see that that's where the bullet entered the seat. This picture over here on the right, and I hope you all can see it, shows you that there's a lot of kind of mechanical workings on the inside of the seat. I think those relate to maybe the seat heater or maybe the motorized seat. I don't know. But the point is that this bullet passed through all of that before it came out of the front of the seat, which is that top left corner where the number 3 is. And I'm not trying to be crass or glib about this shooting, but if you were going to intentionally shoot someone because you wanted to kill them, this is
Objection, Your Honor. Argument.
So if you want to share what you think the evidence will show, you're welcome to do that. And then at the end of the proceedings, you're welcome to say, based on this, I think it's shown or failed to show X, Y, or Z.
The evidence is going to show to you that it would be just as likely that this bullet might strike the mechanical workings of the interior of the seat and deflect. Maybe come back and hit Mr. McIver. Maybe go through the seat but deflect and go off at a different angle, go through the radio, go through the side of the car. The evidence is going to show you that it is not a guarantee or even likely that you would be able to kill somebody in this method. And that's why the shooting was accidental and not intentional. Most importantly, there was a witness who was Diane McIver's best friend. Danny Joe Carter had known Diane McIver for a long time, before Tex McIver met Diane. The evidence will show that it's inconsistent with an intentional killing to shoot Mrs. McIver in front of her best friend. You are also going to hear evidence that Tex has a sleeping disorder. It's called REM behavior disorder. It is abbreviated as RBD. So most of us, when we fall asleep and when we dream, kind of a curtain comes down in our mind. So that if we're dreaming that we're running or jumping or whatever, our body is not physically acting out what we're doing in our dreams. People who have REM behavior disorder do experience physical movement while they're dreaming. They can jab and kick if somebody else happens to be in bed with them, because they have whole body jerks. They can have whole body jerks when they're experiencing a dream and they have REM behavior disorder. Mr. McIver has a well-documented history, going back more than a decade, of having REM behavior disorder. And I expect that you will hear evidence about that. I expect you will also hear about something called confusional arousals. And I'm not going to get too far into the details of that with you, but confusional arousals are also sometimes referred to as sleep drunkenness. It's when somebody is startled awake and they are disoriented as to where they are, and they act in a way that doesn't make sense or is inappropriate, maybe even violent. And most importantly, when somebody has experienced a confusional arousal, they can have amnesia, which means they may not be able to recall what exactly happened when they were woken up from their sleep. So I expect that you will hear evidence about that. So let's talk about finances, because the state spent quite a while talking to you about the finances of Mr. McIver and Mrs. McIver. So Tex is 75 years old today. He was, for a very long time, a lawyer and a partner at Fisher & Phillips. It was always part of the plan, as he was getting older, that he would retire. And it was also something that happened to him, which happens to many, maybe most lawyers as they get older and they start to slow down in their work, that he switched from something called an equity partner to an income partner. I don't remember exactly the date when that happened, but it was sometime in the years before 2016. So kind of the important takeaway from that is equity partner means generally you're making more. Income partner means you're still making a good salary, but you're not making as much as when you were an equity partner. And so I expect that you are going to hear from witnesses from Fisher & Phillips that it is very normal and usual as lawyers advance in their career and they start to get towards retirement age, that they start to slow down, that they change from an equity partner to an income partner, and eventually retire. I also expect that you will hear that Tex remained an equity partner for much longer in his career than most attorneys usually do. At the time he announced his retirement, which was in 2016, so it's not that he lost his job at the firm or he lost some status at the firm. This was part of a plan of his to retire as he got into his 70s. That he still had a big book of business, which essentially means that he had clients who were sending their business to the firm, generating quite a bit of money for the firm. Those clients were very loyal to him, and this was in 2016. So Tex planned to retire from his firm. We absolutely agree that Diane was making more money than Tex. I think the evidence will show to you that as his income was kind of going down over the years, that hers was either staying the same or going up. And yes, he was relying on her income every month. In part, she was contributing to expenses at the ranch. And I'll talk a little bit more about the ranch in a second. I think the evidence will show that it is inconsistent for Tex to want to cut off that flow of income from Diane McIver, because that was something that they had planned for. And the plan was that they were going to pay off the debts so that as Tex got into retirement and he no longer had that income from his law firm, they wouldn't have any debts to pay, and they could live off of that retirement income they had planned for. So before I talk about the ranch, let me kind of tell you briefly about Tex and Diane's relationship. They met in about 2000. They dated for about 5 years before they got married. They both had both been divorced before, and the divorces were not amicable. And by the time they got married, they were both older. They were both well established in their careers. They were both financially secure. So when they got married in 2005, the way that they chose to handle their finances was by keeping things separate. And as the state told you, Diane McIver paid for certain expenses, usually the ones related up to the condo in Atlanta. And Mr. McIver had things that he paid for. Doesn't mean that they didn't kind of jointly contribute to things that involved both of them. Mr. McIver had owned the property out in Eatonton before he met Diane. But when he met Diane right before they got married, she came to love the ranch too. That's what they called it, the ranch. And so she contributed financially to making improvements on the ranch before they got married and after they got married. For example, after they got married, she liked to have the flowers changed out twice a year. So that's something that she would use her money to do. And when they got married, Mr. McIver changed the deed on the property so that instead of it being solely in his name, it was now in both their names with rights of survivorship, which meant that if one of them died, the other one would have the deed to the ranch all by themselves. The same was true for Tex. If Tex died, Diane would have the ranch all in her name. If Diane died, Tex would have the ranch all in his name. So in 2011, there is this note that is secured by the ranch for $350,000. Tex made payments on the note. Yeah, we agree that you'll see that the note says it's due in either 2013 or 2014, I can't remember. He didn't pay off the note by that point in time, so they renewed the note. They extended its due date out to 2017. And while they had this document that seems businesslike and rather formalistic, don't forget that these two individuals are in a marriage. It's not as if Diane said to Tex or was going to say to Tex, you're late on your payments for 2 months. I'm going to foreclose the ranch and take it from you. I mean, they were married. They were in a loving relationship. This was something that they worked through together. And the evidence will show you that in 2014, they agreed to extend the note out a little bit farther. One more thing about the loan on the ranch. The loan on the ranch doesn't go away when Diane dies. There's nothing in the document that says if Diane dies, this debt is forgiven and you don't have to repay it. I expect you will hear the evidence that Tex is still making payments on that loan to this day. We don't dispute that both Diane and Tex were contemplating making changes to their will. They both had a will that was drafted and executed in 2006, which was It was executed either before Austin was born, or it was executed at a time when he had just been born. So he hadn't really, he was in their lives, but they hadn't developed that close connection with him that they both developed as Austin got older. So Austin is their godson. They both loved him dearly. It's not as if Austin was only Diane's godson. Both Diane and Tex treated Austin as if he was their own child. They both loved him dearly. They both wanted to provide for him in the event that either one of them died. This is not something that Diane was contemplating doing all by herself. And that's another reason why Tex would not intentionally shoot Diane, because he knows that Diane loves Austin, and Austin loves Diane dearly, and he would never take her away from him. Let me also address something that the state brought up in their opening, which was this auction that happened after Diane passed away, where her belongings were sold to generate money for the estate. I expect the evidence will be that that was done on the advice of a lawyer named Stan Smith, who I expect he will come tell you that he was the one who said we need to hold the auction of these items and we need to do it now. The reason being, there's kind of two reasons that go along with that. One is that in particular the furs are obviously a winter item. So you are more likely to get more money for the furs if you have the auction when it's cold than if you do it in the middle of the summer. The second is that just kind of generally clothes sort of lose their value over time. So you don't want to hold on to clothes and sell them at the next cold season because they may not generate as much money when they're sold. So I expect that you will hear Stan Smith come tell you those two things, as well as tell you that it was his advice to hold the auction when it was held in I believe, January of 2017. And the auction was held because Diane made specific requests in her will. There were people that she identified that she wanted to receive money, people other than Tex McIver. And the money needed to be raised to satisfy those requests. And I am confident we're going to be diving in to the details of what was in her will, how much money was raised, what was in her bank accounts. So we will have plenty of detail on that as this trial goes on. And while I am on that point, the state's opening spent a lot of time talking about what Mr. McIver did do or didn't do. And I think the evidence will be that there's not some sort of playbook or set of ways that somebody is supposed to act when their spouse has died suddenly and violently, and probably even worse, that your spouse has died at your own hand. I can't imagine anything more traumatic that could happen to an individual. And if there was a certain way that Mr. McIver was supposed to act, well, I don't know where that's written down. So let me move on now. We step away I've been talking a lot about facts that relate to the first 4 counts of the indictment. So let me transition and talk about the last 3, which are the influencing witness counts. The first one deals with Danny Jo Carter. The count charges that Tex told her essentially to tell the police that she was a family friend. The count alleges that he had this conversation with her on September 26th when they were at the hospital. So Danny Jo Carter is given a couple different statements. She is interviewed by the Atlanta Police Department on September 26th, right after the shooting happens. She doesn't say anything to the detectives about Tex telling her to lie. And first of all, just the idea that Tex would tell her, hey, you should tell the police you're just a family friend, doesn't make any sense at all, given that A, they're on camera when they pull up to Emory Hospital. It's clear that Tex is not driving the car. B, it's clear that there's no way Diane could have been shot in the back by Tex unless he was sitting back there and somebody else was driving the car. So it just doesn't make sense that he would go up to Danny Joe and say, hey, why don't you just tell him, you just showed up and you don't know what happened. But on September 26th, I think the evidence is going to show that she is specifically asked by Detective Smith, did you and Tex have a conversation about what to tell the police or what not to tell the police? He's giving her an opening. He wants to know. She says, Tex said he hated for me to be drugged into this mess. She doesn't say anything about Tex telling her to lie or Tex telling her that she's a family friend. When she's interviewed again on September 27th, she doesn't say, hey, by the way, I forgot to tell you something yesterday. Actually, Tex told me, I needed to lie to you all. She doesn't tell her husband that Tex told her to lie. Tom Carter says that Danny Joe said, Tex said, I hate to see you caught up in this, which is consistent with what she told the police on September 26th. It's only much, much later, and I'm not sure if it was weeks or months later, that she tells the DA, oh, Tex told me that I ought to lie. So that count fails. You're going to hear this voicemail to Tom Carter. I put the date of October 4th up there. I may have written that wrong. Maybe that it was on October 6th. Whatever the date is, you'll hear this short voicemail that he left for Tom Carter. But you've got to put it in context with the timeline of events that had happened. Diane shot on September 25th. Danny Joe has already been interviewed on September 26th and 27th. Importantly, Tex is interviewed on September 28th. So before he ever calls Tom Carter, he has already gone and told the police that A, he shot Diane, and it was an accident, and B, that Danny Joe was driving. So why on earth would he then call Danny Joe through Tommy Lee, her husband, and say, you need to now change your story? He's already told the police exactly what has happened. And by the way, there is nothing that Danny Joe said to the police that hurts Tex. She tells the police this shooting was an accident. She tells the police that Tex and Diane had a wonderful relationship and she was jealous of it. So why on earth would he call her up and say, now you need to change your story? That count fails. So let me talk about Bill Crane briefly. As the state said, Bill Crane is somebody who was sort of a PR spokesperson for Tex in the kind of days and weeks after Diane died. Bill Crane puts out this statement to the media and says, Tex said that there were Black Lives Matter protesters in the area of Edgewood at that exit, and that's why he got the gun out. This statement was not meant to inject any kind of racial bias or racial animosity into this case, but the press latched onto it, sensationalized it, probably to sell some papers. And so Tex started getting a lot of blowback for the Black Lives Matter comment from the community and from friends. Bill Crane will tell you that he was getting a lot of sort of testy communication from Texas law firm. They were telling him things like, you need to take our name off your webpage. So that's the context of this statement. And don't forget that September 26th, what time we're dealing with. On September 23rd, that Friday before Diane died, there was a Black Lives Matter protest at Lenox Mall, right across the street from Tex and Diane's condominium. There had been other reports from all around the country that summer and that year about Black Lives Matter's protests, some of which had gotten violent. But there's two important things to remember about Bill Crane's statement and why this count has got to fail. First, as I said, Bill Crane was the PR spokesperson. There was no reason that Tex would ever think he was interfacing with law enforcement.
Objection, Your Honor.
That's what I think the evidence is going to show.
It's argument, Your Honor.
Okay, I'm just going to remind you to hew to what you think the evidence is going to show rather than arguing whether a count fails.
The evidence is going to show that Bill Crane was not dealing with the Atlanta Police Department, that Tex didn't think Bill Crane was dealing with law enforcement or the DA's office. And that's part of the count, that there's got to be some intent to influence a law enforcement proceeding, and the judge is going to give you instructions. But that's one important thing to remember about that count. The second important thing to remember is that whether or not there were Black Lives Matter protesters has no bearing on the question of whether this was an intentional act. That's the important part of the case. Who was at the exit when they got off doesn't matter. That's the second important thing to remember about this count. It's not a crime, had nothing to do with misleading a witness. So let me finally touch on Jeff Dickerson. Jeff Dickerson comes into the picture kind of later in 2016. Jeff Dickerson is going to tell you that at some point Tex said to him, if you can get the charges dismissed, Tex had been arrested, but there was no indictment at that point in time. But if you can get the charges dismissed or get the DA not to bring an indictment, there's a success fee in it for you. This was not a serious comment. And in fact, it was a stupid comment because it could be easily misinterpreted like it is now. Tex did not mean for Jeff Dickerson to run off and try to bribe Paul Howard. And the evidence is going to show to you that there are a lot of reasons why that's not true. First of all, he doesn't say to Jeff Dickerson, go tell Paul Howard that I'm going to pay you a success fee if you can get the charges dropped, and that you'll share it with Paul Howard. That's not what he says. Second, Tex never followed up with Jeff Dickerson. Hey, have you had that meeting with Paul Howard yet? Did you tell him about the success fee? When are you going to have that meeting? Is something on the calendar yet? None of those conversations ever took place. They never discussed the amount of this supposed success fee. Tex wasn't trying to bribe the DA. He wasn't attempting to commit a crime. Jeff Dickerson, I think the evidence will show, didn't think that Tex actually meant he ought to go bribe the DA, because Jeff Dickerson doesn't go tell Tex's lawyers, hey, you know what, your client just told me that I needed to go commit a crime, that I needed to try to bribe the DA. He doesn't go tell Paul Howard, hey, Tex McIver just tried to get me to commit a crime. He doesn't tell anybody about this conversation until some 14 months later. And, most importantly, Jeff Dickerson doesn't quit working for Tex. He continues to be paid about $3,000 a month. That shows he didn't think Tex was seriously intending that Jeff Dickerson go bribe the DA. This some 14 months later, that Jeff Dickerson is having what appears to be a casual lunch between friends with Paul Howard when he is no longer working for Tex McIver. And somehow this comes up. Why Jeff Dickerson mentions it to Paul Howard, I don't know. The thing I know that the evidence will show is that it was not an intentional statement. It was not a serious attempt to bribe the DA. It was a comment that has been misinterpreted. So finally, let me just wrap up by telling you I think the evidence is going to leave you with some key questions that you're not going to be able to answer. And if you can't answer these questions, you can't conclude that Mr. McIver intentionally shot Diane.
Objection, Your Honor.
Your Honor, I don't understand how this is different from the state's last slide that said you must find him guilty.
Okay.
This argument, all of these questions are arguments.
Why don't you just share with the jury what you think the evidence is going to show? You've cast it in the form of questions, and then you can wrap up.
The evidence is going to show that Tex shot Diane accidentally in front of her best friend, and that this is inconsistent with intentionally wanting to shoot and kill Diane. The evidence is going to show that when the gun discharged, they were by Piedmont Park, not somewhere out on I-20, not out in Putnam County, where the ranch is, where it's remote and there's no hospital nearby. The evidence is going to show that the gun was held sideways, that it was shot through the plastic bag, as I said, that it was shot through the car seat, which had all the interior mechanical workings, that the evidence will show the bullet could have been deflected or slowed down or come apart. The evidence is going to show that the gun entered Mrs. McIver's back in her lower to middle back. And then finally, the evidence is going to show that Tex was relying on Diane's substantial cash flow and income every month, and there was no financial reason for him to cut that off. The evidence is going to show to you, ladies and gentlemen, that Tex loved Diane and Diane loved Tex, that she was his best friend, and that he would not intentionally kill her. He did not intentionally kill her. He did not murder her, and he is not guilty. Thank you.
Thank you, Ms. Clark Palmer. We're going to take a quick break. This will be our first break, so we'll see how that process works.
The breaks are always as long as you need them to be. They may end up longer if we're working through things. We're not working through anything yet because we're just about to start with witnesses. So what we're going to do, I'm going to have Deputy Murphy check to see if sort of a 7-minute-ish break, so we're starting at, it would be 11:15 on that clock, is enough time. And if it's not, you're not done with what you need to do, you just tell Deputy Murphy and you get more time. But as soon as you are ready, at least with this break, we'll be ready. There'll be times when we're not ready, even though you're done, because we're working through a motion or who knows what. You mind taking a seat? Thanks. We'll see how all that flows, and we'll start to get a rhythm with things. If there are issues with what's going on back there, they're out of toilet paper, you're out of water, anything like that, let one of us know, and we'll address it. I do need someone to move this monitor so our jurors, we don't get a civil lawsuit falling from this. So if you can step around and gingerly do so, but that someone's coming up right now to move that monitor out of the way. We'll get you back in here 5-6 minutes, if that's enough time for you all, and start with witnesses. Thank you.
All rise for the jury.
Please, if you mind moving, I don't know why we're putting all these hazards. There's a dolly there with wheels. Can you mind moving that?
Oh, no, sir. I'll take care of it.
Great, okay. And no banana peels down there for them either. Anything from the state before we break? No. Your first few witnesses are ready to go? Yep. Great. Anything from the defense? No? Okay. We'll see you in a little bit. Thanks.
That's fine.
Yeah, no, because Elegant and I overlap. So
may have like a foundational objection to it, we'll have to deal with that when we
Sure.
see what the witness says. And then 130, Your Honor, is just the handwritten note. I guess we'll just wait to deal with it when it comes in, because I just don't know what it is.
Okay.
But so
14, 30, and then you're flagging 130 is one that will need to, may need to be some foundation / context set. I have down here, photo is a, 14 is a photo of ranch-patio.
Yes.
Perhaps it's that sign we heard about.
yeah, did we already talk about the sign? I missed it.
Pre-you, we
Yes.
heard about what the sign said.
Yeah, well, I don't know if you're going to be able to see it. It says we don't dial 911. And that's the picture of the gun underneath it.
Okay. I see that. So your objection is?
It's irrelevant, and it's also ought to be excluded under 403.
Okay. Mr. Rucker? Ms. Convery, your witness?
Your Honor, yes, this will be my witness.
Sorry.
The photos that accompany 14 in the series of photographs of the ranch just depict the property the jury just heard about in detail from both parties. I intend to show the jury a series of photographs about the ranch, and of course this court knows that we expect the evidence to show that the ranch, the condition of it, and everything surrounding the circumstances of how it appeared are relevant to the state's case and what we need to prove.
Do you believe there's going to be any evidence that Mr. McIver was unaware of that sign being on the wall of his ranch?
But that is not my argument. My argument is he doesn't know about it. So now there's going to be other pictures the state will introduce that adequately depict the porch, that will adequately show this jury the condition of the ranch. They don't need to show this sign, which has, I can't understand what the probative value is at all, especially based on what the state just said. And B, it is unfairly prejudicial. And that the jury may look at this and go, oh, well, he has a sign that says we don't dial 911.
Okay. And then 30? Let's put 30 up, please.
30 is a picture from the interior of the ranch. I've zoomed. Let me zoom out first.
That's okay. This is the wall of pictures. I haven't seen this picture, but
Right. And this is a picture, and I don't know if this witness knows, but so it shows somebody and they've got blackface on. It's a picture of Mr. McIver's grandfather from a long time ago.
okay. If we unzoom it out for a second, I find it real hard to see what's in that one. Oh, but that's really one of the few things on it. What's the point of 30?
There are a series of, right around 30, there's sort of a walk through that hallway. That particular wall of the residence is family photographs, friends photographs. I intend to discuss with the witness sort of the layout of the ranch and how it is, each portion of the house is sort of decorated and arranged in detail. I don't intend to make any specific comment about State's Exhibit 30 or zoom or focus on that.
Is there something particularly relevant to the state's presentation to that ceiling corner of that hallway or room?
All of these photographs just depict the ranch as is.
Okay.
People would be coming to visit the ranch, and this is the condition that the guests and friends of the family would observe the ranch in.
Got it. And on 130, you're going to lay some foundation as to relevance, provenance, etc.
Yeah, I haven't marked it in this particular witness's folder because I intend to ask her questions about a conversation. This is a sort of photograph of a handwritten note that the defendant wrote. I do not intend to tender it with this witness, but should it become relevant, I wanted to have it marked for her.
Okay. Well, we'll see how it plays out.
It was something that was agreed. It's from the document, it's from the log, from the boxes, and this was in the first series of documents that we actually agreed on.
Okay, great. I will allow 14 to, assuming there's a foundation laid for it, to be admitted and published with the jury. I will not allow 30 to be presented to the jury, so I'd just skip over that. I don't think we need to renumber anything.
Yes.
It'll just be you're presenting your stack of photos, just 30's not in there, and we're not going to use 30 unless something really changes about what we're talking about.
While I have the court without the jury in here, I will just make an announcement from the record. I do intend to tender 2 photographs that contain images of Austin's Wall, who of course the court knows is a juvenile, State's Exhibit 4 and 5. I do not intend to publish those to the jury.
Okay, so they'll be admitted, ultimately they may go back with the jury, we can work through that, but they will not be published.
Yes, and we may publish to the jury sort of privately, but I should have clarified, but I won't be projecting for media purposes because of the child's age.
Okay. Anything else, Ms. Clark-Palmer? Are you going to have to do everything in this case?
Everything.
Anything else before
Typical men.
before we get started? No? Okay, let's bring the jury in, please.
Yes, Judge. All rise for the jury. All jury members are accounted for, Your Honor. Please be seated.
Thank you, Deputy Murphy. Welcome back, ladies and gentlemen. I'm going to give you B- for switching seats, but some of you did a good job of sitting somewhere different. We are ready to begin the state's presentation of its case. During this break, it ran a little late, not because I forgot about you, but as I forecast, something did come up, and we needed to discuss a few items so that when the witness is in here, we have fewer potential interruptions. There may well be objections and whatnot, but the attorneys did a good job of saying, here's something we're concerned about up front, and we worked through that. The witness that it sounds like the state's going to call is going to take longer than we have before we break for lunch. We're going to break for lunch at about 12:30. I have to go to a meeting elsewhere in this building, so that's our hard stop. We'll start getting a sense for how long you all want for lunch. I want to respect your need to get away and recharge, but a 2-hour lunch will mean we have a whole lot less time in court. A 45-minute lunch means we have more time in court. So we'll see what works for you all in terms of getting someplace where you actually want to eat the food and getting back here and being ready to go. But expect that we'll stop right about 12:30 for our lunch break, and then we'll get back in action after that. So the state will call its first witness, please.
Yes, Your Honor. State calls Miss Janie Calhoun.
Janie Calhoun.
Ms. Calhoun, before we proceed, you raise your right hand. Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am. For the purposes of the court's record, please state your name and spelling.
Janie Calhoun, JanieCalhoun. Yes, ma'am.
Good morning, Miss Calhoun.
Good morning.
You're soft-spoken like I am, so make sure that you scoot forward as close to that mic for me as you can.
Okay.
And speak up nice and loud into the microphone so everybody over there in the jury box can
Okay.
hear you. Let's start by having you introduce yourself to the members of the jury. Tell them your name again and how old you currently are.
Janie Calhoun, I'm 68 years old.
And are you currently working?
Yes.
Tell the jury, what do you do for work?
I work for Trinity Services Group. I'm a consultant in sales. In the jail and prison business, we do food services.
And how long have you been working for Trinity?
Since 1998.
And you're a consultant for Trinity, you said?
Yes.
Tell the jury a little bit about sort of your day-to-day role there at Trinity. What does your job have you doing on a regular basis?
I am marketing development sales, and I also do public relations for the company. Any contracts I have, I keep up with those contracts, entertain the clients. I do trade shows. That's all part of my job, and I just do it in Georgia right now.
And you said you just do it in Georgia right now?
Yes.
Before being assigned exclusively to Georgia, did your job take you other places?
North and South Carolina, a little bit in Texas.
And does your job require you to travel on a regular basis?
All over Georgia, for sure, yes.
Okay. Are you currently living here in Atlanta?
Yes,
Do you split your time between Atlanta and anywhere else?
Dallas, Texas.
Tell the jury why that is.
My husband works out of Dallas, Texas. He's a consultant also, and that's his home base. We have a condo there that he works out of. He works in Oklahoma City, California, Virgin Islands, Puerto Rico.
And how often is it that you are actually in Dallas?
For the last year, I've spent more time there than normal. I'm usually there about 2 weeks out of the month.
Back in 2016, did you and your husband share this Dallas-Atlanta sort of layout that you described to the jury you have now?
Yes, it was more on the weekends, but since all this happened, I'm spending a lot more time during the week there.
All right. Tell the jury, what is your husband's name?
Leslie Ball.
And how long have you all been married?
We've been married 10 years. We've been together 19 years.
I want to start on this morning by telling the jury was Diane McIver to you?
Diane and Tex lived in the condominium next door to me, and we became really good friends. She was like a sister to me. We spent an awful lot of time together, so we were back and forth to each other's condo a lot during the week.
Okay. I'm going to show you a series of photographs. For the record, I have previously shown to defense counsel. It's marked for identification as States Exhibit 1 through 5. No objection. Can I approach?
You may. Both sides have continuing authority to approach witnesses to share exhibits and whatnot.
All right, Ms. Calhoun, I'm going to have you take a look at States Exhibit 1 through 5. Let me know if you recognize those.
Yes.
And how do you recognize each of those photos?
The first one is Diane McIver. The second one is Diane McIver. The third one is Tex McIver. Fourth one is Diane and Austin Swall, their godchild. And the last one is Diane and Austin, their godchild.
And each of the photos that you have in front of you, are they a fair and accurate depiction of the people that you just told the jury about?
Yes.
All right, this time the state's going to tender what's marked as 1 through 5 into evidence.
No objection?
Correct.
Okay, they're admitted.
Is that permission on this?
You do.
Tell the jury who is in State's Exhibit 1.
Diane McIver.
And you told the jury that the two of you were like sisters. Tell them how your relationship, how is it that you first met Diane?
I had met Diane probably years back in the early 90s, but it was because of the legislature and Billy Corey, her employer. I had met her, but I did not know her personally. When we moved into our condo, which is next to theirs, that was in 2005, the end of 2005, and I met her again at that time, and then in 2006 we got to be really close. We spent a lot of time together.
And what was it about 2006 that brought you and Diane to be close friends?
Because we were neighbors, I think. We went out to dinner some, and just she and I were both a lot alike. We both were hardworking business people. We both grew up very poorly and worked our way up to where we're at in our positions. So it's we had a lot of the same things in common.
And as you continue to become closer to Diane and get to know her, do you also kind of get an understanding for who she is as a businesswoman?
Very smart. She was very strong. She had built Corey Industries, I felt like, to the point that it's at right now.
And you mentioned Billy Corey before. Tell the jury, who is Billy Corey?
Billy Corey is over, I believe it's more called U.S. Enterprises, but most everybody looked at it as Corey Industries. But
And what is your understanding of what they do at U.S. Enterprises? Kind of work?
they had advertising. At one time, they had a lot of liquor stores. They owned a lot of real estate. They did airport advertising, and that was one of Diane's big things she pushed to get forward, and it was a big opportunity for them.
Do you know what Diane's role was at U.S. Enterprises, what her sort of title was there?
She was president.
And in your time getting to know her and becoming close to her, did you did you learn her story with Corey when she started there?
She started back when she was 19 years old. She put herself through college at night and worked with, Corey the whole time and just moved up within the industry.
Did you have occasion to get to know or meet Mr. Corey as you sort of developed your friendship with Ms. McIver?
I knew Billy Corey probably before Diane because of the legislature. I was a lobbyist at one time and was at the legislative sessions a lot, so I had heard about and met Billy Corey, attended a lot of functions with him.
And were Billy Corey and Diane close?
Yes, very close.
Describe for the jury a little bit more about that relationship. Was it boss-employee or was it different in any way?
It was boss-employee, but Billy came over to her condo a lot during the week, especially after Austin, their godchild, was born, and Billy loved being around Austin too, so he would come over a lot at night and have dinner and see him when Austin was there.
And in your time getting to know Diane, did you also know the defendant, Mr. McIver?
Yes.
Tell the jury how you first met
I first met Tex back in 1997. Got to know him a lot better when he and Diane got married.
And did the couple have any children that you know of?
Tex and Diane not together, no.
Did Diane have any children from her previous marriage?
No.
What about Mr. McIver?
Yes.
Do you know how many?
He had 3 children.
Okay. And do you know about how old they were in, let's talk about 2016. You know about how old his children were?
I have no idea. I really don't.
That's allowed. You mentioned Austin. Tell the jurors, who is Austin?
Austin is Diane and Tex's godchild.
And when did Austin come into Diane's life? You know.
Right after he was born, and that was in 2007, I believe.
Okay, and I showed you before and had previously been admitted to States Exhibit 4 and 5. And for the record, I'm just going to approach the jury public. I'm going to show them first States Exhibit 4.
Yes.
Tell the jury, what are we looking at in States Exhibit 4?
That's Diane McIver and Austin Schwall.
Can you tell about how old he is in this photo?
Oh, looks like he's around 7 or 8.
Tell the jury, I'm going to show also for the record States Exhibit 5. Do you recognize where States Exhibit 5 is taken?
It looks like at the ranch,
Okay.
just from that picture.
Tell the jurors, if you would, a little bit about Diane and Austin's relationship.
He was like her son she never had. She loved him dearly. She and Tex both did.
In your time with Diane and becoming close friends with her, about how often during a regular week would you say that you saw Diane?
At least 2 or 3 times a week.
And how often would you see Austin there?
He was there at least a couple of times a week, sometimes more than that.
We just showed the jurors a photograph that you described as being taken at the ranch. Tell the jurors, when you say the ranch, what are you talking about?
It was in Putnam County. It was a big house. They had a lake out in front, and then there was I say a house behind the house. They called it the saloon, but it had a bedroom and it had the stables for the horses, and that was there.
In your time getting to know both of them, had you actually been out to the ranch yourself?
Yes.
And when you would go out to the ranch, where would you stay?
If my husband was with me, we stayed out in the saloon, as they called it. It had a master suite out there. And if I went with just Diane and Tex, and sometime Danny Carter would go with us, I would sleep in Austin's bedroom in the main house.
All right. Your Honor, I won't ask you. I'm going to show you Ms. Collins what has been marked as State's Exhibit 6 through 69, except for 30, and as well as State's Exhibit 163 and 164. You've had a chance to previously look at these photos for me.
Yes.
Will you just quickly flip through them? Let me know if you recognize them.
Okay.
6 through 69, except for 30. 163, 164.
Sorry.
Is there a supplemental exhibit list, or I should just, this goes to 161?
Yes, we will have supplemental.
Okay, great.
These are all made at the ranch.
And in this first, well, I'll talk about all of them. In State's Exhibit 6 through 69, and then 163, 164, do you recognize each of those photographs?
Yes.
And how do you recognize each of those images we're talking about?
These were at the ranch, or on the ranch. They were where we did shooting practice.
Okay, and you're talking about 163 and 164?
Yes.
For the rest of the photographs, do you recognize them as the ranch as well?
Yes.
And for each of those photos, does it appear to be a fair and accurate depiction of the ranch as you remember it, and your personal experience being out there on that property?
Yes. I didn't see the rooms where the guns and the bullets were all kept. I don't think I ever was in there.
And let me know which of those images you don't. And I'll take those out.
Oops. I don't remember seeing that.
This is okay.
Never saw that. Let's see this.
The rest of these photographs that we're talking about, are they a fair and accurate depiction of the ranch property as you personally remember it?
Yes.
Right, and Your Honor, I'm going to tender as previously marked, except for State's Exhibits
I might have gotten them out of order.
53 through 68.
So 6 through 52, except for 30, and then 69, 163, and 164.
Exactly.
Okay. We talked about one of those images outside the presence of the jury. You preserved that objection. Anything else?
I was going to have an objection, but I think we have dealt with it. I'm just confirming. Okay, so other than as previously stated, no objection.
Okay, I'll admit those.
Thank you.
Tell the jury what we are looking at in State's Exhibit 6.
That is the entrance as you're coming to, well, it's the fence that is around the property itself, and you see the front lake, and the house is at the back of that.
Just so we can orient the jury.
Stop.
I'm sorry, and I apologize. It's very difficult for us to hear over here because witnesses behind the court's bench.
Sure.
I'll lean forward. Is that better?
Thank you.
Sorry, I have a soft voice.
Okay.
All right, so just so we can orient the jury when we're looking at State's Exhibit 6, and you can actually, if the court's monitor is working, actually press on the screen, and you can mark. Tell the jurors how you would approach that property if you're pulling up there in a car.
To the left of the white fence, there's a cement driveway that goes into the drive where the house is.
So on the far left side of the image there.
Yes.
You can do it 7. What do we see in State 7?
Yes, that's the driveway coming up to the house, and where the cars are parked out front, there's like a circular drive, and then to the left, it's where the car garage is.
Do you see the circular
Yes.
drive you're talking about in State
Yes.
7? And this, the house that we're looking at in State's Exhibit 9, is that what you're sort of describing as the main house?
Yes.
State's Exhibit 11.
That is the driveway if you would be coming in or leaving the house. It's coming around the circle is where it is, and then there's a walkway that goes down to where the lake is.
And is the lake sort of what you see there as you approach the property on the front?
Yes.
Are there any other bodies of water on the property?
Yes. There's a lake behind the saloon house.
And for the jurors who haven't been out there, how would you describe the saloon?
It was more an entertainment, I guess, and for their guests to stay in. It had a big, entertainment area with TVs, and then upstairs there was a master bedroom, and I think there were 2 more bedrooms.
And where is that in relation to the main house that you spoke at?
It's exactly right behind it. There's a pool in between and a little walkway over to that house.
What do we see in State's Exhibit 4?
This is the porch as you're coming into it's a screened-in porch that as you're coming into the back of the main house, and that door is the entrance into where the kitchen is.
Is the front of this area we're looking at actually screened in?
Yes.
Describe for the jurors as they're looking at this photo and some of the other ones we're going to look at. How is this property decorated?
Very Western, I was brought up on a farm in South Georgia, so to me it's very country also. The signs that were depicted were a lot of things that you would see.
And State's Exhibit 15, is that another angle of that same?
Yes, same back porch. Mm-hmm.
Right, and what about State's Exhibit 17?
That's still part of the screened-in back porch. It goes out to where the pool is, behind the main house.
The water that we see in 17, is that the pool?
Yes, yes it is.
State's Exhibit 19 might be the
It would be, I don't know if you can see me pointing, but it would be to the right side of where the pool is. There's the,
Press very hard on your screen.
oh, okay.
I don't think that it works up there in this courtroom.
No, it's not working here. But there's a fence, and the wood fence, and that's where the cattle and the horses are behind that.
When you're out on the property, did you ever horseback ride?
I did once or twice.
Do you remember about how many horses were on the property?
Oh, goodness. I think that there were maybe 8 or 10.
What about cows, if you know?
Oh, there were a lot of cows. I have no idea, but a lot. And a lot of baby calves, yes.
Do you have an idea, as you sit there, about the size of the property, about how big it was?
I think it was around 75 or 80 acres, I think.
What is these days? Is it 20? There.
I'm sorry?
What's in State's Exhibit 20?
That's the dining room in the main house.
Okay. And State's Exhibit 22?
That would be that was their den area. It was right off the kitchen.
Also the main house?
Yes.
What about State's Exhibit 25?
This looks like Austin's playroom, which probably would have been a sitting area if a long time ago before Austin came along. But that was his toy room.
Okay. Where if you're walking into the front doors of the main house, where is the playroom?
It's on the left-hand side as you walk into the front door.
And State's Exhibit 26?
This is their den living area that looks back into the kitchen in the main house.
So through the sort of windows of this walkway, that's the kitchen, correct?
Yes. Mm-hmm.
Do you see anything in State's Exhibit 26 that you also associate with Austin, or Austin being there in the ranch?
His high chair that he sat in probably until he was 8 or 9 years old. He loved those high chairs.
Sat in the high chair, really? Okay.
He just loved them.
Obviously, Austin, the jury, we've been talking about Austin actually being out at the ranch. Tell the jury a little bit about Austin's birthday parties at the ranch. Have you ever been in attendance?
Yes.
And what were those like?
They were great parties for a little boy growing up. Petting zoo. A lot of his friends would come in from Atlanta and be at the party. And he pretty much, through Diane and Tex, met all of their adult friends, so there were a lot of all of us there at his parties also.
And who was responsible for hosting those parties?
Tex and Diane.
In State's Exhibit 31, we're still looking at the main house.
No, this is the saloon house behind the house, I guess.
And what is just so the jury can get oriented, what's the perspective from this picture? Where is?
Okay, the door that is opening right there is coming in from the main entertainment area, and it's the stairs go up to the master suite.
As you're walking into this property, I think you told the jury you'd actually stay here yourself.
Yes.
What is on either side of the walls there, if you remember?
There's a TV on one side. There's a bar that's on the left-hand side. There's a pool table as you come right into that entertainment room.
And I'm sorry, I probably asked a bad question. State's Exhibit 31, what you see there, just right there in the stairwell. Do you remember what's depicted on either side of the walls there?
A lot of pictures. Maybe I just need my glasses on. More pictures.
Guest house or main house?
That's the guest house. This is more where the stables and where all the working tools for the ranch were kept.
Horses out here?
Items for the horses were there, but the horses were mainly outside. This looks like it's in the wine cellar, is where this is. Yes, in the wine cellar. Yes.
Where in the house or guest house is 641?
It's up under where the den living space is. They dug out up under the house and built it, but you enter it from where all the tools to work on the ranch, there's a door that goes into it from that hallway in the back.
Is it 42 another angle the same?
Yes.
We can see a lot of wine, 642.
Yes.
Who is the wine person?
They both were wine collectors. They knew a lot of people in the business, boutique wineries, and
Any particular kind of wine that you recall?
a lot of different kinds. Reds, whites, cabs. You know, they love to collect wine.
In your time getting to know Diane and Tex and being out at this property, did you have occasion to drink wine with them?
Yes.
Both fans of red wine.
Yes.
Outside on the property, you take to exhibit 164. Tell the jury what do you see there?
That's the target practice mound.
And where, if you're coming up that front drive there and we're sort of looking at the main house in that circular area we talked about, where is this in relation to that?
It's further back on the property, back in the woods, in the property
Have you
access.
been out there yourself?
Yes.
Tell the jury what kind of goes on at the backside of the property where this mound is.
We would practice target shooting, either with plastic containers out there, or we had the target shooting, just I don't know what you call them, but anyway, we would see how close we could get, I guess, to the dots on that.
In your time out at the ranch, have you actually been out there to target practice or shoot with Mr. McIver?
Tex and Diane both were there.
In your time getting to know the couple and being friends with Mr. and Ms. McIver, did you have the occasion to see Mr. McIver have and use handguns?
Yes.
About how often would you say?
We didn't go target shooting every time I was there, but maybe if I was there once every couple of months, we would do it. I don't know if they did every weekend, but would go target shooting when I was there.
And in your time target shooting or being with the couple while there's handguns, would often sometimes be around?
A few times he was there, yes.
And were you able to hear Mr. McIver talk to Austin or anyone else about gun safety?
Yes.
Tell the jury about that.
He was always very cautious of all of us, making sure we held the guns down after we shot. Of course, I had never shot a 9mm, so I had problems with my hands pulling the revolver thing back, but he would load the gun for me. But yes, he was very good at teaching Austin all the safety, how to hold it, keep it down, don't point it up,
And talk to you about safety as well.
Yes.
In your experience out there, when he would talk to you and assist you with loading the gun, in your opinion, was he fairly knowledgeable about weapons?
Yes.
Objection, Your Honor. Calls for speculation.
Your Honor, she has a basis for personal opinion on that specific issue.
I'll allow it based on the foundation laid.
How often would the two of you, would you say, about the same estimation that you gave to the jury before, about how often the two of you would be shooting or around weapons, you and Mr. McIver?
I'm sorry, could you repeat that?
Sure, kind of a weird, I asked it weird. How often would you be around guns with the defendant, Mr. McIver? About?
I think I stated earlier, maybe if I was there twice, 2 times, 2 months, maybe we would go shooting one of those times. I don't think we went every time I was there, but I don't know how often they did it when I was not there.
Sure. One of the things, or one of the people you mentioned earlier was Danny Joe. Tell the jury, who is Patricia Carter?
She was a really good friend of Diane's. I think they've been friends for about 40 years.
And was she, from being friends with Diane, fair to say that you got to know her as well?
Through Diane, yes.
And what was her nickname? What does she go by?
Danny.
Okay. How often would you say that you saw Danny Joe either at the ranch or the Buckhead condo? About?
Okay, maybe once every couple of months.
Okay. And would some of those times be at the ranch, or were they almost exclusively at the Buckhead property?
I saw her more at the condo than I did at the ranch. I think Danny went to the ranch a lot more with her than I did.
We talked about the condo, and I think you told the jury that your condos were close. Describe sort of, if you would, for people who haven't been to your building, sort of the layout of your condos in relation to the McIvers.
Okay. Our building is a 58-unit building. It's sort of a small, not a high-rise. It had 4 units to each floor. And Diane had put 2 units together on the right-hand side of our floor, and then there was a lobby in between. And I had a unit on the opposite side, and there was one directly across from me.
And so did you all have to share an elevator?
No, there were 2 elevators that came up to each floor. It didn't just come off on your floor. It went to every floor in the building.
And was there a common hallway at all?
Yes. Mm-hmm.
I'm going to show you a series of photos that I've shown to defense, and it's going to be 60 to 70 through 162, and then States Exhibit 70 through 88.
Okay.
You've seen these before, but take a
Yes.
quick look through those for me.
70 through 88 and 162?
Yes.
Okay.
Do you recognize those?
Yes.
How do you recognize those pictures?
Some of the pictures are of my unit, and some of our lobby hallway in between our units. And this one is in Diane's 2 units that she put together. It's the hallway that connects the 2 units.
Okay. And because this one kind of does not go with the other, States Exhibit 88, you recognize that as well?
Yes, it was Tex vehicle.
For each of those images, 70 through 88 and 162, do they appear to be fair and accurate depictions of what we're talking about?
Yes.
All right. The state's going to tender 70 through 88 and 162.
No objection, Your Honor.
Those are admitted.
Let's start with States Exhibit 162. What can the jury see in 162?
What was your question?
What was in 162?
This is the hallway between the two units that Diane had put together. So that was how you went from one unit into the other, unless you were outside in the hallway. They had two separate front doors. But if
This
you
is
were,
an internal image?
Yes.
Not the, you were calling it the lobby that
Yeah.
separates your unit from those two?
correct, this was inside their unit.
And the image that we're looking at in 162, this is there because she made 2 condos, 1 condo, is that right?
Yes, correct.
And the table and the mirrors and all that, that's who's doing is that?
Diane's.
I'm going to show you State's Exhibit 73. Tell the jury what was in 73.
That's our lobby area in between our units.
When you say our, who are you?
Well, Diane and Tex's unit, you're seeing straight in front of you, and then the 2 elevators are the dark elevators on the right-hand side, and then the section in the middle is our lobby that separates their units and mine and another lady that lived across from me.
State's Exhibit 72.
This is the living room of my condo.
The seating area there right when you walk in.
Yes.
For jurors who have not been into the McIver condo, how would you describe that unit? You told us it was once 2 and now 1. How else would you describe it?
The one unit on the left-hand side, if you're facing going into their units, was, I call it their main living condo. That's where their master suite was, their living area, kitchen. The unit that was combined on the right-hand side was more entertainment, big, huge TV, and it had a master suite on that side.
And how did parking work?
We have parking levels that we pull in up under the building, and we have 2 parking spaces for each unit.
And I'm showing you on screen right now 83. Do you tell the jury what we're looking at 83?
Okay, if you pull in to the front of our building, there's a visitor parking area that is on the main level, right as you go up under the building. So this is the parking for visitors.
And you actually have an assigned level here.
Yes, you go up through a closed gate, and we all have, there's like, I think it's 3 floors, really double floors. I guess it's 6 floors of parking. You have 2 assigned places.
Is State's Exhibit 82 one of those areas or more of the visitor?
That's still the visitor parking.
State's Exhibit 88. Tell the jury how you recognize that photo.
That is Tex McIver's SUV.
And in 2016, before Diane passed, do you remember about where the couple usually park this vehicle?
Their parking is on the top main level. They had 4 parking spots because they had 2 units, and they were parked on the main level. P3, it's called to us.
Tell the jury, Ms. Calhoun, if you can, in your time getting to know Diane McIver, did you know her to loan people money on a regular basis?
She did loan some people money that were friends or that worked for her.
And tell the jurors, in Diane's terms, what was the loan? What did it mean to loan somebody money?
Well, she always wrote up the loan